So let us look at the PepsiCo case and now look at the diverted profits tax issue. Just to recap the facts, you have the PepsiCo group. It has the Stokely Van Camp subsidiary, which owns the Gatorade brand, and together they signed a contract with Schweppes Australia, which is an independent party and a subsidiary of Asahi Breweries, I believe, in Japan. That contract was assigned to an Irish syrup-making entity, but ultimately the syrup was made in Singapore, sold to a company with the name of PepsiCo Singapore, but it was actually resident in Australia, and it then sold the syrup to Schweppes under contracts called EBAs, and these only talked about the sale of syrup, not about any licensing fees, even though they did give Schweppes the right, but also the liability to use the PepsiCo and the Gatorade brands when selling the soft drinks that they made. The commissioner, when it attacked the structure, first said that there should have been a royalty withholding tax, and secondly, as you can see here, that PepsiCo and SVP should be subject to a diverted profits tax. If we look at what the judge said in the case, if we look at the judge's conclusion, it concluded, ultimately, he said, had I not concluded that the royalty withholding tax provisions applied, I would have concluded that the diverted profit tax provisions apply. So PepsiCo would have paid tax no matter what. And he says the key issues are, one, whether PepsiCo or SVC obtained a tax benefit through the scheme, and two, whether it would be concluded that a person who entered into a part of the scheme did so for a principal purpose, so we talk about a principal purpose test, of either enabling the taxpayer to obtain a tax benefit or both obtain a tax benefit and reduce the relevant taxpayer's liabilities to tax under a foreign law, or to do the same for the taxpayer or another taxpayer. And then the court also says the US double tax agreement does not have a role to play in relation to the diverted profit tax, as Part 4A is carved out of Section 4.2 of the International Tax Agreements Act. Now you see that in all countries that the diverted profit tax laws say, oh, by the way, the treaty does not apply to these essentially income taxes. Unfortunately, that's not the way that tax treaties work. I mean, they are subject to the Vienna Convention on the Law of Treaties, and treaties need to be executed in good faith. And you can't just go and implement an anti-abuse rule on income tax avoidance or evasion and then say, oh, by the way, the treaty doesn't apply for this tax that I've just created. You can agree with your tax partner that it is a anti-abuse rule and therefore it's allowed to be applied. But to just say, you know what, our diverted profit taxes are not income taxes covered by an income tax treaty is a bit weird way of fulfilling your good faith obligations under tax treaties. First, the judge dealt with whether there was a tax benefit. And he said the issue is whether PepsiCo or SVC obtained a tax benefit. And Section 177C, paragraph BC, calls for a counterfactual analysis. And what they mean by counterfactual is look at what did not happen, right? So if you say that if kangaroos did not have tails, they would fall over. That is a counterfactual analysis. And here the judge says 177C deals with tax benefits and relevantly provided a reference to the obtaining by a taxpayer of a tax benefit in connection with the scheme shall be read as a reference to the taxpayer not being liable to pay withholding tax on an amount where he either would have or reasonably might have been liable to pay withholding tax on the amount if the scheme had not been entered into or carried out. So BC is one of the examples of where this diverted profit tax would apply. And then the amount that for tax benefit shall be taken to be for paragraph BC, the one we just looked at, the amount referred to in BC. Now, elsewhere in the judgment, they say the diverted profit tax is 40%, and then the amount, as you need to interpret it, is the whole amount of the deemed royalty. So instead of paying 5% under the treaty on the deemed royalty amount, the diverted profit tax would have been 40% of the total royalty. And the court then, the judge goes on to say, in my view, had the scheme not been entered into, it might reasonably be expected that the relevant EBA would have provided for the payments to be made by the Singapore entity to be all of the property provided by the PepsiCo entities rather than the concentrate. So what the judge continuously does is it says, you know, all of the properties is not just the syrups, it's the syrups plus a right to use all the brand names, right? I accept the first counterfactual of the commission because this was with the commissioner's counterfactually, then add a second one, but the judge does not have to deal with that. First, I'm required to have particular regard to the substance of the scheme. Under both the EBAs and the counterfactual, the payments to be made by the Singapore entity are in substance for both concentrate and the license of the intellectual property. Now, what the judge keeps on forgetting here is that the EBAs, at least the SVC EBA, does specifically mention that, you know, there is a royalty-free right to you license to use the brand names, right? So it's not as though they forgot that. I mean, the contracts are full of references to you must use the brand names, but they also say, by the way, there is a license-free royalty for this. Secondly, I am required to have particular regard to any result or consequence for the taxpayer that would be achieved by the scheme. Again, the amount of the payments is the same under the EBAs and the counterfactual. The only difference is that the payments are expressed to be for all of the property, again, syrup and the IP. So the counterfactual says, if you've done the proper contract, you would have paid for two separate things, but it would still have been the same amount. Insofar as PepsiCo parties submitted in their outline of opening submissions that the Commissioner's counterfactuals would introduce complexity into pricing of the FOBO model, so that is when it's not a PepsiCo company which is doing the bottling, but it's a foreign company, which is designed to be simple. The evidence shows that there is considerable scope to negotiate the pricing terms, and that such terms can have a degree of complexity in them. So what happened? There was quite some paragraphs spent on this. The judge said, why don't you just make the contract so that you pay X for the syrup and Y for the royalties? And PepsiCo said, we never do that because we want to keep things simple. We have one price that we negotiate, and that is enough already. If we start splitting it between syrup and license fees, then we get discussions about, whether there is development of the brand and all that stuff, and whether that should be discounted or not. And you get two targets that you can shoot at instead of one. It introduces complexity, and the judge simply could not understand this argument, or would not understand this argument. So the judge goes on and says further, in any event, the Commissioner's first counterfactual does not involve any change in the amount of the payment. It is therefore difficult to see why it would increase complexity in relation to the pricing, right? And as I said, the judge had difficulty understanding this concept of negotiating one package instead of two different packages. And this is really the substance of his argument in both cases. And it's a pity that he didn't get it, because if you look at the judge's CV, and I will post in the bottom a link to it, he's very well accomplished. He's done academically extremely well. He's also teaching, but he's never been in business in his life himself. He's been a barrister, but that is not being in business, right? Here the judge, I say, show a fundamental lack of understanding how business works. This is not a matter of logic, it is a matter of creating another opening. And you can see this in paragraph 208 and further. The fact that there already have been a variety of prices is supporting the taxpayer's argument, not the Commissioner's. So what the judge says, even with your one price, I see you negotiate different prices with different parties, so there is complexity already. So what can be more complex than just splitting the price in two? But what the judge doesn't understand is the fact that there is a variety of prices already shows that parties are trying to pay as little as possible for the syrup and the use of the brand. And if you get them two things to negotiate discounts on, it will be even worse, right? If the price had been split, there would have been even more negotiations, not the same, and certainly not less. As payor, one would have two targets to shoot at, not just one. And then if we look at the principal purpose test, the judge say in relation to the principal purpose, the 2017 explanatory memorandum at 416 indicates basically that the principal purpose is a lower threshold than other thresholds, in the sense that you very quickly get to a principal purpose. It doesn't only have to be one principal purpose, it can be one of many principal purposes. But if tax saving is one of the principal purposes or tax benefit, then you get into the realm of the diverted profit tax. In answering the inquiry about purpose, it's necessary to have regards to the matters in 177J2. I will now consider each of the matters in 177D2. And 177J2 refers to 177D2. So that's why there's this cross-reference. But it's interesting because we're now looking at the diverted profit tax Australian law. And when you come to the principal purpose test, the law says you need to consider these number of factors and conclude from the outcome of that whether there has been a principal purpose in diverting the profits. And then the first one is the manner in which the scheme was entered into or carried out. Now, if there has been convoluted, if it's been overly complicated, that would show that there is something false about this, right? The next criterion would be the form and the substance of the scheme. Look at the time the scheme was entered into and how long is it. Look at the result that would have been achieved by the scheme. Look at any change in the financial position of the taxpayer that may result from the scheme. In other words, are they better off? Any change in financial position of any connected person being a change from the scheme. Remember when we looked at the diverted profit tax in the beginning, the judge said, I need to look whether there is a benefit for the taxpayer, either in Australia or abroad, or for any other person, right? So now you also need to look at other persons and whether they are connected. And then along the same veins, you need to say any other consequence for the taxpayer or the person under paragraph F. So not only a tax scheme, but are there other benefits? Because if there are significant other benefits and they dwarf the tax benefits, then maybe the tax benefit was not a principal purpose. And then the nature of any connection, business, family, or otherwise between the taxpayer and any person under paragraph F. So the judge now goes on and goes through this list and see what goes on, right? It says section 177D2A refers to the manner in which the scheme was entered into or carried out. And PepsiCo parties says that the EBAs have been the way they've been since the early 1900s, way before there was an Australian diverted profit tax, in other words, and the standard pricing structure under that model, which had also been in place since the early 1900s. So both the way the contract looks and the way that the products are priced. The PepsiCo parties admit that these matters point strongly against PepsiCo and SVC having a principal purpose as described in 177J1B. And the judge reluctantly agrees. He says, I accept that these matters point to some extent against the presence of a principal purpose. However, in my opinion, they do not take matters very far. There is no detailed and comprehensive evidence as to why, as of 2009, the PepsiCo group generally adopted the pricing structure in its exclusive bottling agreements, or, for that matter, why some others in the beveraging industry also adopted the structure. And we come back to this issue, I mean, if everyone is doing it, the fact that PepsiCo is only doing it for tax reasons might not be the case, especially not if it's been doing it since 1900, right? So the judge is shooting himself in the foot with this argument. It would not be safe to assume that the tax considerations did not have a role to play. In as far as Mr. Williams gave evidence that the pricing model was adopted because it was simple, I have difficulties with that evidence, and we've already discussed that issue, right? And so the judge goes through the other points as well. He concludes first, I could therefore consider that this matter supports PepsiCo's parties on purpose, but only slightly. And then he moves to the next point. He says, 2B refers to the form and substance of the scheme. If there are material differences between the form and the substance, this may support the evidence of having a requisite purpose, right, being a principal purpose. And he says, in the present case, in my view, there is a disconnect between the form and the substance of the EBAs. In form, the payments to be made by SAPL, for that Schweppes, right, were for the concentrate alone and not for the license of the trademarks and other intellectual property. However, in substance, the payments to be made by SAPL were for both the concentrate and the license. So the judge says, aha, here you see there is a principal purpose test trigger, because what you wrote on paper and what you do in practice are not exactly the same under the counterfactual, right? There is therefore a disconnect between the form and the substance of the scheme. This matter strongly supports the Commissioner's position that the requisite purpose did exist. And you can literally smell the bias of the judge here. I note that in the PepsiCo party submissions, the amounts SAPL paid to PBS were included in PBS's assessable income in Australia after claiming deductions for the purpose of the concentrate. And we talked about this in a previous video. I said, so this the Singapore entity that sold the syrup to Schweppes, I mean, it was incorporated in Australia, but it also was a taxpayer in Australia. But it didn't pay a lot of tax because it had to pay for the syrup to the real Singapore entity. So there was only a very thin margin left in Australia. And this is what the judge addresses here as also. He says the deductions claimed for the concentrate from CMSPL represented almost the entirety of the amounts that PBS received from Schweppes. I note also that CMSPL is incorporated in Singapore, a low-tax jurisdiction. Now we get to Singapore itself. In the Commissioner's outline of opening submissions, it stated that the applicable tax rate for CMSPL in Singapore was 0%, and PepsiCo did not deny that. And we come here, I mean, I am sympathetic to PepsiCo in this case, but it is not because they are good taxpayers. It is simply because the facts of the case does not support the conclusion of the judge. But so you had a base erosion scheme in which the Australian companies paid for the syrup. Now, I mean, they had to get it somewhere. And that money went to Singapore, right? So there's a deduction in Australia, no pickup in Singapore. And if you just spend a minute here and think about how Pillar 1 and Pillar 2 will work here, Pillar 2 will definitely make sure that there's a withholding tax. There's a minimum tax of 15% in Singapore. Pillar 1, of course, will allocate the difference to Australia and not to the US, right? So Australians might be happier with Pillar 1 and Pillar 2 in this particular set of circumstances. And then the judge goes on to say, Section 177(2)(e) refers to any change in the financial position of the taxpayer that may result from the scheme. And then he says, under the scheme, PepsiCo or the SVC did not receive any royalty income under the EBAs. Under the counterfactual, they did receive a royalty income. And the judge goes further. He says, this refers to the result in relation to the operation of any foreign law relating to taxation that would be achieved by the scheme. In oral closing submissions, senior counsel for PepsiCo parties accepted that prior to 30 June 2018, any royalty that would have been paid to the US would have been subject to 35% tax. from the 1st of January, the difference in the effective tax rate under the scheme compared with the Commissioner's counterfactual was 10% versus 13.25%, so it was only 3%. And that is, how much of a deduction do you get in Australia and how much tax do you pay in the US? And I mean, if you get a deduction of, 15% or 20% in Australia for what you pay for these royalties, but you have to pay 35% tax in the US, then obviously you pay tax on a much higher income than what you get a deduction for in Australia. And then this is what the judge is saying here. And he says, this is also an indication for that there's a reason or a motive for the scheme. But I don't agree with this. Because if PepsiCo and SVC did not receive a royalty, they would have received the money for selling the syrup ultimately. And this is where I really get into problems with this case, because the contractual party initially was Ireland, not the US. The US then required the payments and the invoicing to go through Singapore, and the Australian commissioner and the judge just accept that these income streams must be taxable in the US. But now one wonders whether they think that only the royalty should have been taxable in the US because that is where the brand owners are, or whether also the syrup income should have been taxable in the US. And if they say no, because the syrup was made in Singapore, so it should be taxed in Singapore, then not only do you take a third-party contract and split it into two, one for royalties and one for syrup, but you're also dragging in a whole new contract party into the third-party relationship. I mean, even under transfer pricing, you rarely see such an extreme form of recharacterization. And I wonder whether this case will be appealed, I am pretty sure, or settled out of court. But I very much doubt that, I very much hope that PepsiCo does not accept the judge's outcome and pay the $4 million just because they pay much less under the 5% US royalty withholding tax treaty than they would have paid under the diverted profit tax Australian law, as it turned out to be. And then just to wrap up, the judge's final conclusion is, I consider that it would be concluded that one of the principal purposes of each of PepsiCo and SVC was to entering into or carrying out the relevant scheme, and it was to obtain a tax benefit. And then, as we saw in the beginning already, the judge says, had I not concluded that royalty withholding tax provisions applied, and that was the first plea of the commissioner, I would have concluded that the diverted profit tax provisions would apply, and that was the second plea of the commissioner, which is very strange because, again, there's 5% withholding tax under the US treaty with Australia on royalties. There's 40% diverted profit tax. Why the commission didn't go for the diverted profit tax first, I don't quite understand. I hope you enjoyed this video. Next time we're going to look at what the parties did here in terms of valuing the royalties, because we're looking at 5 different methods in that, and that is quite an interesting aspect of this case as well. Bye for now.